just briefly, the Conrad Black petitioners are arguing that that they could not reasonably have foreseen any economic damage to the plaintiff or to the company. I'll let Walter talk about what Jeffrey Skilling is arguing, but I think the main thing for purposes of political law is whether or not we're going to have the Sun-Diamond theory of law reestablished, which is there has to be an actual quid pro quo in order for a public official to be charged with corruption, or whether this sort of more amorphous honest services fraud will be a theory upon which government prosecutors can rely to prosecute mainly public officials and public employees, but also corporate employees.
Thank you. I should have pointed out earlier that Cleta had an interest in the Citizens United case, but I think she made that clear enough on her own, don't you? If in the future, when I stand up, it'll be, what is it, the yellow light or the red light? I'll give you a few minutes of grace. Next up is Orin Kerr, who will talk about a few of the criminal cases. Orin is a professor at GW Law School and, as you probably know, a prolific blogger on the Volokh conspiracy. He writes more often than I do.
Not as well. Thanks, Bob. It's a pleasure to be here. This term is a great term for those of us interested in criminal law, criminal procedure issues. There are a lot of really interesting cases to follow, and I think you can break the cases down into the cases where it's likely that Justice Kennedy is the key vote, other cases where it's likely that some other justice is the key vote, and then there are some cases where you just throw up your hands and say, I have no idea how this one's going to play out. And I wanted to break down my brief remarks into picking examples of each of the three. So the first case I wanted to talk about is a case where Justice Kennedy is likely to be the key vote. Graham versus Florida, and then the related case of Sullivan versus Florida. These are two very similar cases that raise very similar issues. The question is, under the Eighth Amendment, whether it's cruel and unusual punishment to have a penalty of life in prison without parole for a minor who committed a non-homicide offense. Let me say that again, because it's a pretty specific category. Life in prison without parole for a minor who committed a non-homicide offense. In the Graham case, the individual was 16 years old when the crime was committed. It was a burglary robbery. And in Sullivan, it was a individual who was only 13 years old, but the crime was particularly heinous, a sexual assault of an elderly woman. In both cases, the individuals were sentenced to life in prison without parole. In the Graham case, there was an intervening cause of a probation violation. But in both cases, the issues really boiled down to what do you do in the Eighth Amendment setting with the prohibition on cruel and unusual punishment when on one hand it's not a capital case, so maybe the capital cases apply, maybe they don't. And then on the other hand, you've got a minor. So maybe the special cases on the rules for minors apply, maybe they don't. The briefs really frame the issue as a discussion, as really an analysis in Roper versus Simmons, the controversial 2005 case, which was a 5-4 decision by Justice Kennedy invalidating the death penalty for individuals who committed their crime at the age of 16 or younger. And the questions raised by the case are, well, if you've got a minor, and you've got that part of Roper versus Simmons, is Roper applicable if, on the other hand, it's not a capital case? In other words, is death different? Or are death and life without the possibility of parole kind of similar? So you have, in that case, the one argument is, well, Roper versus Simmons applies in the case of a non-homicide offense. In other words, life in prison without parole for a non-homicide offense is sort of the equivalent for a capital charge for somebody who committed a homicide. This is opening the door to the possibility of applying the Supreme Court's Eighth Amendment limitations that have been developed in the capital setting to the non-capital setting. And the big question is whether the court is going to do that. And there, I think, the briefs are very clearly directed to Justice Kennedy, very closely following the analysis in Roper versus Simmons. These cases also bring out the possibility of a favorite issue for the Federalist Society, citation to foreign law. Some of the briefs talk about United Nations resolution saying you can't have life in prison without parole for minors, and relatively few countries allow this. So that's another likely to be a very controversial case, and one to watch in terms of whether the Eighth Amendment jurisprudence the Supreme Court has developed in the capital setting will begin to expand. Another case that's quite interesting to watch is a case, Briscoe versus Virginia, a confrontation clause case. This is a very similar case to a decision last term, Melendez-Diaz versus Massachusetts. The question is one that's actually tremendously practically important, and it involves mostly narcotics cases. In narcotics cases, the key evidence in the case is going to be a certificate by the government that says we ran lab tests on these narcotics, and it had, in fact, contained a certain narcotic and in the following amount. And the question is whether the government needs to put forward the lab technician to testify about the certificate under the Confrontation Clause, which says you have a right to confront the witnesses against you. In Melendez-Diaz versus Massachusetts, 5-4 decision of last term, the Supreme Court says that the certificate alone is not enough. The government needs to come forward and provide the actual witness, the actual lab technician or the individual who ran the test to testify, so that way the defendant can cross-examine the witness in case there are any irregularities in the testing. What's fascinating about Briscoe is that Briscoe is very similar to Melendez-Diaz, and the big speculation is why did the court agree to hear the case? So the normal procedure that the court would have followed would have been to grant, vacate, and remand this other case, the Briscoe case, saying we just answered all these questions in Melendez-Diaz, lower court, take this case. And figure out what to do in light of our new decision. And in fact, the Melendez-Diaz decision seems to have language kind of answering what to do in the situation of Briscoe versus Virginia. And what's fascinating about Briscoe is instead, at the end of the term, the Supreme Court grants the Briscoe case. What makes that particularly interesting is that Justice Souter has left. And Justice Souter was the fifth vote in Melendez-Diaz. So the question is, what's Justice Sotomayor going to do? This is the example, as I said, of a case where someone other than Justice Kennedy is the really interesting vote to watch here. Justice Kennedy is the author of a very impassioned dissent in Melendez-Diaz. The speculation is that maybe the four dissenting justices, which were Breyer, Robertson, Alito, in addition to Kennedy, wanted to have another case to sharply limit, if not actually overturn, Melendez-Diaz. And with a change in court personnel, it's possible that will happen. It's important to note there are ways in which the court could take the Briscoe case and limit Melendez-Diaz without overturning it, but that's a very critical case to watch, and it'll be fascinating in particular to watch what Justice Sotomayor does. One of the reasons it makes it particularly interesting to watch is that of the various areas where she has decided cases as a lower court judge, the criminal justice cases are the ones that are, I think, on the whole, less ideological. She's former state prosecutor and arguably may end up being sort of more pro-government than Justice Souter was in the area of criminal procedure. So that's a big case to watch. Last case I wanted to talk about is the one where it's just too hard to know who's going to be the key vote, and it's United States versus Comstock. This is a federalism challenge. The question is whether Congress had the power to enact a law allowing for civil commitment of individuals who are leaving federal custody. So typically it's going to be somebody who's just served a penalty and serving in time in federal prison, and there's reason to believe that they are sexually dangerous. So this is a law that was passed in 2006 designed to basically keep sex offenders off the street. And the idea is that if somebody there's evidence to believe that they are a sexual offender and would reoffend, they can be kept in federal prison even though their federal sentence has expired. So they serve their term, but nonetheless are held subject to a fairly complicated regime. There has to be annual review of the continued detention and other requirements.